Good morning, everybody. My name is Gregory Spaun. I'm from the law firm of Welby, Brady, and Greenblatt. Welcome here to the Building Industry Center. We're doing another presentation in our Breakfast Roundtable series, this one on New York's marijuana reforms and what employers need to know, particularly within the construction industry. By all means, if you have any questions as I go along, pop your hand up. I like a lively presentation, so feel free to ask questions. If you have questions later after the presentation, or if you're watching online later on, feel free to email me, gspaun, G-S-P-A-U-N, at wbgllp.com. So, what are we talking about today? We are talking about the Marijuana Regulation and Tax Act. Now, what is that? It was enacted in 2021, and it effectively legalizes marijuana and other cannabis possession for use. Adults 21 and over can possess, use, and transfer up to 3 ounces of cannabis. You can also possess 24 grams of concentrated cannabis. So that's what goes into your gummies, your brownies, your edibles, and whatnot. You can also cultivate up to 3 mature plants and 3 immature plants at a time. So you have 3 ready for use at any one time and 3 in the pipeline. If you have a 4th plant that gets mature, you better harvest one of the other 3 because it's a 3 and 3 limit. Again, personal use is personal use. It is not meant to encourage home drug dealing. Importantly, you can give your homegrown crop or anything you buy, you can give it away, but you cannot sell it. Again, the state's not looking to make any drug dealers, but if you want to share with your friends, go ahead. An important provision of the Marijuana Regulation and Tax Act is that if you had some issue years ago as a younger adult or a juvenile where the issue was marijuana possession, that conviction is now automatically expunged, as if you were never convicted of the crime at all. Importantly, and this is a distinction, it is still, for now, illegal under federal law. We don't know when or if that'll change, given the tide of how many states are adopting similar legalization schemes. Ultimately, it may come to the federal level where we can get some uniform legislation which will be applicable to all 50 states. But until that time, or until it is rescheduled on the Schedule of Controlled Substances, it is still a Schedule I substance under federal law and therefore illegal. What does this mean for employers? Well, it means that you have a chance of now running afoul of the Legal Activities Anti-Discrimination Law found in Section 201D of the Labor Law. This means that your employer can't punish you for legal activities that it otherwise disagrees with, provided you're doing it on your own time. It's an important regulation with regard to free speech, union activities, or whatnot, and now it's been expanded to include legal marijuana use. It prevents the employer from discriminating against an employee for otherwise legal activities. Again, political activity, union activity, now legal cannabis use. It does not require an employer to turn a blind eye to marijuana. Just because it's legal doesn't mean that you have to tolerate stoned employees on your job site. There is a balance. You can ban, as an employer, you can ban smoking marijuana wherever you ban tobacco. Just because ordinary tobacco is disfavored doesn't mean that you have to tolerate marijuana. At the end of the day, smoking is smoking, and you can ban it. You can also ban smoking marijuana during working hours. Again, you don't want stoned employees on your job site, and like you can ban drinking and should ban drinking during working hours, you can also ban the use of marijuana. Importantly, this includes both on and off-site breaks. In the old days when we were dealing with alcohol, it was called the liquid lunch, and the employer could prohibit that. Well, now if they want to smoke at lunch, you can prohibit that as an employer as well. It also includes an on-call period. If you are sitting at home, you're off the clock, but you are subject to being called back, your employer can say you've got to stay clear-headed during that period as well. Also, anytime a company vehicle is being used. Again, a lot of employers give a company vehicle. This way you can use it at your discretion. It's part of your compensation package or whatnot. But clearly the employer doesn't want you driving its car, van, truck stoned. So you can prohibit marijuana use when somebody's going to be behind the wheel of your vehicle. You can also ban marijuana possession at work. You don't even have to tolerate it on your job site, regardless of whether it's being used or not. It does not apply to non-employees, this statute. So if you have an independent contractor, a student, a volunteer, you effectively can say, okay, no marijuana use at any time, and undertake activities which otherwise might violate Section 201D of the labor law.
Greg, I have a question on that one.
Sure.
For our non-employees, our independent contractors, our subcontractors, can we put that as part of a contract for no marijuana use on the job site?
The question was for people who might not have heard the question with the microphone, can you ban it? Can you require a subcontractor to ban marijuana use, etc., by its employees? And yes, you can, provided that their program complies with Labor Law 201D. You can't require somebody else to violate the law for doing what you can't do. By independent contractor, they typically mean like what would be otherwise called a 1099 employee. They're an independent contractor. Typically like a court reporter uses that kind of a model where the employees of the agency, the reporters, are not actually employees. They're independent contractors. But as far as retaining an entity to subcontract, you can, in fact, you should require that they comply with the labor law, but to the extent of, what as an employer you're permitted to prohibit.
Okay.
So we now have our first case on the Marijuana Regulation and Tax Act, Moore versus Exwell. It's out of Supreme Court, the trial court in New York County, Manhattan, for those who don't know specific geography and that borough names don't always coordinate with county names. It applies the Legal Activities Anti-Discrimination Act, Labor Law 201D, to cannabis use. There, an employee walked in to work smelling like cannabis, was told, get off my job. They were fired the next day for smelling like cannabis and being impaired. Moore sued, Exwell moved to dismiss. Hey, they smelled like cannabis, I'm not discriminating, I'm just requiring that they not use marijuana on my job site, which is permitted. The court upheld the complaint and allowed the lawsuit to proceed. So what was the reasoning? That the defendants there did not state how the plaintiff manifested specific articulable symptoms while working that decreased or lessened her performance of the duties, the task of her job position. Rather, they just simply stated in conclusory and in broad brush fashion that the plaintiff was impaired in performing her duties. And the court also noted that the mere smelling like cannabis was insufficient to support a present state of intoxication. So it was insufficient to support the dismissal of the plaintiff's claims. That lawsuit is proceeding. The facts may develop that there were other issues that were brought to somebody's attention that would support that, yes, this employee was impaired and therefore the termination was lawful. But at the motion to dismiss stage, merely saying that she was impaired and smelled like weed was not sufficient. Again, weed is something like many smoke substances. It sticks onto clothes. It sticks onto soft surfaces. So you can, for instance, take a shower in the morning, wear clean clothes, get into a car where you smoke marijuana. You get out of the car, you're smelling like marijuana, even though you didn't touch the stuff that day. So importantly, smell alone is not sufficient. There has not been an appeal filed. The case is proceeding. So stay tuned. Importantly, employers are always curious about testing programs. What can I test? What can I do? When can I test? I mean, typically it's pre-employment, random, and you can still do that with regard to illegal substances. As a practical matter, when you perform such a urinalysis or whatever other test you're performing, the chemical test will be the same. What you have to do is tell the testing agency, don't tell me the results for marijuana. Therefore, you're not testing it even though the chemical panel of the test will register. They will just delete that result. It never existed. You're not testing for it. But you have to advise, and again, this has been around for a few years in New York, so these testing companies are wise to this, what they can and cannot tell you. But you can test when it's permitted by a state or a federal statute, regulation, ordinance, or another mandate. Again, it's still illegal under federal law. We'll get into that in a moment. Where your employer would be in violation of federal law. You're a construction company, you're working on a federal job site or federally funded job site. Therefore, you have to comport with the federal requirements. You can test your employees for marijuana to make sure that no employee using marijuana is on that job site. That being said, once that employee is thrown off that job site, if you also do non-federal work, that's where they're going to be working because, again, in New York, it's legal. Your employer, you would lose federal contract or federal funding. You can withhold, you can test when that is a condition. You can test when it's permitted by a collective bargaining agreement. If you're represented by a union and the union has agreed to permit employees to be tested, you can test. Importantly, there was another case, matter of Moran Ruiz versus Ontario County, where the employee was fired for a dirty test, correction officer, and he said, hey, Labor Law 201D, legal activities anti-discrimination. And the employer came back, well, your union agreed to it in a collective bargaining agreement, so we're good to test. You tested dirty, you're fired. It was permissible. Dismissal upheld. So when can't you test? You can't test pre-employment. New York City, if it's a safety job, but there are issues with that we'll get into. Where it's prohibited by your collective bargaining agreement. Again, if the union says you don't test employees, you don't test employees. When must you test? Well, you never have to test, but there are times when obviously you want to. So let's talk about New York City. What are safety jobs? Here's a list of them: construction apprentice, asbestos handler, bridge painter, laborer, bridge maintainer, welder, blasting inspector, correction officer, police officer, lifeguard, pilot. There's a whole list of them, including baker. Somehow that made the list. It is what it is. Now, what's the problem? Well, in the state of New York is contained the city of New York. So, as a political subdivision of the state, it's subject to state law. So while New York City code, local law, permits you to test pre-employment, as a practical matter, state law says you can't. So again, the fact that you're not going to get hit with a New York City human rights discrimination complaint of any kind doesn't mean that they can't sue you in New York State Supreme Court. Now, there are problems with testing. The test does not detect present intoxication. That's a huge problem. You want a get-rich-quick scheme, one that's guaranteed to work, develop a test to test for present intoxication of marijuana. Whoever does that will find themselves retired on some beautiful Caribbean island in a mansion. But until that time, because the tests, unlike alcohol, where if you have a breathalyzer or a blood test, that tells you if you're drunk. That doesn't just tell you if you've used. The marijuana test only tells you that you've used. Now, the problem is that THC, which is the intoxicant, is fat soluble. So my friend over here on the left will test dirty a lot longer than my friend over there on the right. So that's something to keep in mind. Now, medical marijuana was sort of the precursor to outright legalization. Now, we had said that the Marijuana Tax and Regulation Act came in 2021, 7 years prior. New York legalized medical marijuana. Now, patients had to be certified as needing the medical marijuana, and they had to have a card. These people are considered to have a disability. So if they still have the card, they don't need it, but if they still have it, they're considered to be disabled, which of course provides civil rights protections under the Americans with Disabilities Act. You're required to accommodate these employees, but the accommodation only has to be reasonable. If they have a medical marijuana card, you can still tell them, look, you can't smoke on premises, you can't smoke on company time, but again, the accommodation has to be reasonable, but you don't have to tolerate a stoned employee on your job. It does not bar testing or enforcement of a non-discriminatory policy. So what do you do to prevent these guys from showing up on your job? Well, the law does permit employers to discipline those who have articulable symptoms of cannabis impairment that decrease or lessen the employee's performance of tasks, interfere with the employer's obligation to provide a safe workplace. Obviously, that's a large one in the construction industry. You can only test post-accident if there are articulable symptoms of impairment. You can't just test random post-accident. Oh, there was an accident, so therefore there has to be a problem. No, you can test to confirm your subjective belief that there's an issue and to see whether your belief is right. Now, these articulable symptoms include, red glassy eyes, the munchies, lethargy, being tired, smelling like cannabis, but again, we now have a court decision that says that alone is not enough, and just working stupidly. The guy on the outside of the branch that he's cutting down. So what are you going to want to do? You're going to want to train your personnel to detect impairment. And this involves more than just hiring a pothead. You need to have somebody who's familiar with marijuana and has training, because what will happen is when you discipline that employee, they will sue you, and somebody like me will be examining you as to why they were fired. So if you can, on the stand, testify that you've been trained in X, Y, and Z programs, and these are your credentials, almost like you're building up a CV of an expert witness. You want to credential yourself, you want to get the knowledge and education. Again, that somebody may have used marijuana, okay, that may go into the mix, but you want them to have objective credentials as to how they know that somebody's stoned more so than Joe Average. And there's a whole checklist of them. This is the list that you'll see I got from the state of California. Their general checklist for employers to use to document an articulable suspicion of impairment. When they're walking, are they holding on, stumbling, unable to walk, unsteady? Is there something wrong with their gait? Standing, are they swaying? Are they feet wide? Are their feet narrow? Are they unable to stand? Are they rigid? And you can start to see in here that there's a lot of variation in these criteria. Their movements, are they fumbling, jerky, nervous, normal, hyperactive, reduced reaction time, lethargic? Again, these are just checklists that you're going to want to go through to make sure that you're documenting the employee that you believe is stoned. Again, what are their eyes? Bloodshot, watery, droopy, glassy, closed, dilated pupils, constricted pupils. Again, those are both opposite ends of the same spectrum. So you can see that subjective is subjective. There's no set objective test, unlike alcohol. What does their face look like? Flushed, pale, sweaty. The breath. Is there any kind of an alcoholic odor, a chemical odor, a tobacco odor, any kind of a cannabis odor? Are they using breath spray to mask an odor? Speech, what does that look like? Again, they whispering, slurring, shouting, are they incoherent, are they slobbering? There's a whole list. Their appearance, what does that look like? I mean, there's demeanor, how's that? When you confront them and say, hey, we think we have a problem here, are they combative? Are they mellow? Are they, okay, you got me? How does that conversation go? And again, you want somebody trained in the reaction, similar to what police officers have been trained for years at a roadside stop. Again, cops have always had for years and years have had the back of the trunk breathalyzer test or the Alka-Sensor. But as far as marijuana, they're not able to do an on-the-spot drug test, so they've been doing the subjective test for years to detect high drivers. Well, now safety companies and other training companies are ramping up to be able to train your personnel. And for good reason, your personnel should be trained. Again, you look at their actions, you look at their appetite. Again, the munchies is a big one. Are they popping mints? And, miscellaneous. Anything else that can go into the bucket. When somebody's on the stand testifying as to a subjective belief, you're building a brick wall, brick by brick by brick. Okay, he did smell of marijuana, one brick. His eyes were glassy, another brick. He was slurring his speech. He sounded like Bill and Ted's Excellent Adventure. Whatever, brick by brick by brick. Document the issues. This way, you're building that wall high enough to protect you against the ultimate liability in that lawsuit. Again, documentation is key. So I can't recommend highly enough that you have your employees trained, and we will see what comes down the road next with regard to how to deal with these issues. Yes?
Has any of that played out yet? Because at the time it was passed, apparently 2% of the New York State troopers were qualified in this regard. And there were obviously at that point 0% of lay people, employer representatives. Has any of it played out in the courts at all in this, what it worked in now 4 years since?
Well, there are the two cases. Again, the correctional officer who tried to invoke the Legal Anti-Discrimination Act, Labor Law 201D, as a defense to a dirty drug test, and because it was permitted in the collective bargaining agreement, that was permitted to go. And many of the public safety unions, troopers, corrections officers, and whatnot, have testing in their collective bargaining agreements, so they're going to continue to be subject to that. There's also the Exwell case, which provided that you have to build your wall. You have to detail why you believe this person was intoxicated, therefore on the job, therefore you discipline them up to and including termination. Merely smell and, they were stoned is not enough. You have to build the wall and explain how they were stoned. Aside from that, this is all that's played out to date. Unfortunately, the law moves more with geologic time as opposed to human time, so it takes a while for these things to work out. You're welcome.
Greg, I have a question.
Sure.
So with the federal guidelines, if we're working a federal job and they ask us exactly what we test for, are we, if they have THC on there, are we out of our realm?
No. If you're working on a federal job, you can test your employees that are on that job. When you're ramping up to take a federal job, you better have an idea as to who's going to be on that job and who's not going to be on that job. And if you have anybody that is a user on the weekend, they do show up smelling of marijuana.
30 days.
It's 30 days. Or, again, on the weekend, they're driving in the car, they get out of the car and it smells. They're a user, so you're not going to put them on the federal job because they would test dirty. Yeah. But you want to have an idea, and since it's a requirement, if it's a requirement to test, you want to test. And you want to tell the testing agency, hey, I'm doing this because these people are going to be on a federally funded job, or I'm taking a job at West Point or some other military facility or what have you. So you're going to want to do that. Any other questions? Well, if you have any later on, by all means, please email me, gspaun@wbgllp.com. Thank you for listening.